And welcome to the Aaron Katsman Show. I'm your host, Aaron Katsman. We're here to speak to you about your life, your money, and your investments. And as always, we're coming to you from the spiritual and soon to be financial capital of the world, Jerusalem, Israel. If you got any questions or comments, feel free to email me at Aaron, A-A-R-O-N, at lighthouse with an L, lighthousecapital.co.il. That's Aaron at lighthousecapital.co.il. You can check me out on the web at www.aaronkatsman.com. That's www.aaronkatsman.com. You can find me on Twitter, and be sure to subscribe to Aaron Katsman and on our brand new YouTube channel. So it is my honor to introduce our guest this week. It's going to be an interesting topic, and I'll tell you why it's going to be an interesting topic in a minute. But first, I'd like to introduce Mirit Hoffman, who is an attorney who focuses on estate planning and elder law, focusing on interfamily ties and their daily needs of the intergenerational family, right? This entails preparing wills, enduring power of attorneys, and trusts. She is part of the Global Society of Trust and Estate Practitioners, gives lectures all around Israel on the importance of estate planning. She's a mother of three, and without further ado, I'd like to introduce Mirit. Welcome to the show.
Hi, welcome to this. Thank you so much. It's really an honor to be on your show.
So the reason I reached out to you is I wrote a series of articles for the Jerusalem Post speaking about what to do if God forbid, if your spouse passes away. And then I got a lot of reaction, and then I decided to write an article about what to do before, while you're still both married and living together and everybody's healthy and well. And that got like this avalanche of support. And I said, well, I got to speak to Mirit because she's like an expert in this. So Mirit, first of all, tell us a little bit about what you do, especially with, elder law. What is elder law?
Okay, so you were very good actually with the introduction. So it's what I do is really estate planning, basically taking back control regarding issues that you feel you have no control of afterwards, which is preparing your will, which would happen, how you would like basically to distribute your assets upon your death, and the durable power of attorney, which is relatively new in Israel, which is basically planning your future in the event that you, God forbid, lose your cognitive capabilities to make decisions on your own. However, when I go to a client and discuss wills, we have a very first sort of general conversation, maybe if you can explain like that, where we discuss financials at large, because often, like your article, there's usually one of the spouses who is very into the financials and one who has absolutely zero clue what's going on with their monies, and he doesn't even know where the money is necessarily, in which bank accounts. So the first thing I do when I sit with a couple is say, okay, guys, do you know what's going on with your accounts? And usually one will nod and say, yes, of course, we're very. Then the one will say, I have no idea what's going on. And then there'll be sometimes a little bit of a tiff or a tap and go, what do you mean? I tell you, like, okay, let's just stop. Let's start from the beginning. Do you know where your accounts are? And then they'll go, okay, tell us what we need to do. And then the conversation flows. I always recommend that they have some sort of binder or folder where they write everything, even insurance details, even house insurance details, all kinds of information that one of them usually is the one who takes care of all this stuff. And the other one just, signs on paperwork according to what is needed, but really is not with it.
So I'd like to tell you, jumping with that, right? We spoke a little bit before the interview, and I told you my theory, and I'm very, very old-fashioned. I counsel people to write all this information in an old-fashioned notebook on a piece of paper and stick it in a notebook. The name and phone number of your accountant and your lawyer, where your bank accounts are, contact people. Because I've personally seen far too often widows, young widows, who, everything is password protected and they can't access the funds. The husband managed everything. And then all of a sudden, they want to get into the brokerage account and start moving the process to get it in their name, and they can't. So the money's frozen. They don't know where to turn. You have to become like, a hacker in order to computer hacker in order to get anything done. So it's really, really important for both sides to know the contact information and exactly what it is that you have. So can you give us some other tips that you tell your client sort of in the pre-will process of what they should do to get organized?
Sure. So apart from the money issues and insurance stuff, I ask them if they have a longevity clause in the bank, because it's something that usually a lot of couples have, but they're not quite sure. So I make them go to the bank and actually find out.
And that's in Hebrew, that's called, what's that called in Hebrew?
It's called Sif Arichut Yamim.
Okay. And is that the default for the bank? Like when you go to the bank, for people who are making aliyah and what have you, they come to Israel, they go to the bank, and they open up their account. Is that a form that they're going to sign on, or is that something they have to ask for?
It's usually a default, but you know what? Paperwork is paperwork, and there's loads of it, and it should be something that should be even in their back of their mind to just ask the clerk who's dealing with it, saying, do I have this? And I say, oh, they might say, yes, of course, it's in the paperwork. And they might say, you know what, I forgot that piece of paper in front, I have 10 here for you to sign on, and I forgot that one. Good that you reminded me. So it's something that should know, if we're talking about it, something that they should know about. And
if they don't sign it, and God forbid something happens to one of them, what happens to their money at the bank?
So look, in general, let's go back to the default. If they sign on it, what it means is if one passes away, then the other still has access to the joint account, not to start taking out, ridiculous amounts of money, but just for everyday operations, for paying bills until the probate is basically, done by the court, and then the money is completely released. If they don't have it, and they are jointly owned on the account, it really depends. If it's a husband and wife, and they had this joint account from day one, then most likely, they'll speak to the clerk and they'll show a death certificate, and he'll say, okay, I'm not completely freezing the account, but I'm actually going to watch over it much more. So don't buy that, 70 screen-inch TV right now. Just concentrate on the cottage cheese and the milk that you were thinking of buying, and don't start making big purchases. But if it's not an account that they started from day one, let's say it's a child that's been added to the account in the middle of the lifetime of this account, then it could well be that even though he's jointly owned the account, it could well be that they'll freeze his options to actually do anything with the account, because they'll be worried that the child is going to start taking out money from the account. And the bank wants to cover itself until there's a probate of the will to see what's actually written in the will regarding this account, to make sure it's giving the money to the right person.
Okay. So that's the longevity clause. What other tips do you tell people sort of in order to organize their funds and what have you, sort of pre-will stage?
Okay. So then, I check people who have joint, if they're also U.S. citizens, people who have dual citizenship, when preparing a will in Israel, need to take into consideration that they may have estate tax in America. And now, especially now, it may be a big issue, because before, when Trump is still president until January something, but now that he's changing his presidency, things with estate tax is going to be very different. Up until now, we had an 11.8 with linkage, an exemption, 11.8 million per person who is as a U.S. citizen for estate tax, and then above that was 40%. Most people don't have that amount of money, so it was less of an issue. But according to rumors, Biden is probably going to lower that to maybe even 3.5, and he's planning on upping the taxation from 40% to 60%, and suddenly that becomes an issue.
Okay.
So that's something that they need to be aware of.
Okay, Mirit, how can people get in touch with you?
Well, they can definitely call me on my cell phone number, 0522 407 999. They can email me on my email, mirit@lawmirit.com. They can contact me through my Facebook pages and through my website.
Great. This is the Aaron Katsman Show. I'm your host, Aaron Katsman. We speak to you about your life, your money, and your investments. If you've got any questions or comments, feel free to email me at Aaron, AARON, at lighthouse with an L, lighthousecapital.co.il. That's Aaron at lighthousecapital.co.il. You can check me out on the web at www.aaronkatzman.com. That's www.aaronkatzman.com. You can check me out on Twitter, and be sure to subscribe to the brand new YouTube channel where you get all of this content directly into your inbox. So we're speaking with Mirit Hoffman, who is an estate planner, an elder law lawyer, who focuses with
a lot of L.
yeah, I guess, whatever. And we were talking about getting things ready, getting things in order. Now, pre-will. And what I'd like to sort of shift into now is speak about sort of the will process. A big question that I get often for Americans who live in Israel is, should they have one will in Israel? Should they have two wills? Should they only have an American will? Like, can you try and clarify, the issues, and then, what sort of should be done?
Okay. So in general terms, if somebody has most of his assets in Israel and just has a bank account or a brokerage account in America, then most likely does not need to prepare two wills. One will in Israel will be enough. I suggest they always check what they have in America, as in, do they have a transfer upon death? Because that would make it much easier for them. They won't need to go through any probate system whatsoever. And if they have a brokerage account, then I would check with their brokerage advisor, with their investment advisor, what paperwork is needed. Sometimes only a death certificate, which maybe needs to be translated and notarized, is sufficient enough in order to transfer the money, and there's no need for anything else. If it's something that they have substantial, like actual real estate and more significant assets in America, then I do recommend that they have two wills. Two wills meaning one would relate only to the assets in Israel, and the other would relate only to the assets in America. And it should be extremely important that they don't overlap over each other, so they don't cancel each other out.
In Israel, maybe we should have prefaced it. It's very important to have a will in Israel, correct? Because of just the way that Israeli law is. Can you talk about that a little bit?
Sure. So a lot of people think, oh, you know what? It's just me and my husband, and everything afterwards goes to the children. Why do I need to have a will? There's really no point. But they don't realize that according to the law, if a spouse passes away and they don't have a will, then it's 50-50, meaning my half, the person who passed away, his half of whatever asset was, let's say a house. So his 50% of the house, taking into consideration that the house is divided between the two of them, so 25% goes to the husband and 25% goes to the kids, meaning that the house is 75% now owned by the husband, but 25% is owned by the children. Now, there could be cases where the children say, you know what, Dad, we're giving you the 25%. We don't want it. When, I'd never slim, and then we'll get it from you. That's great. But I actually had a very sensitive conversation with one of my friends who said, you know what, I don't want to do that, because my mom is young and she might get remarried, and then she might transfer that asset. She might will it or not will it. If she doesn't prepare a will, the new husband will get her share, and then I'm left with nothing for my dad. So I don't want to give her my percentage, which I just got as an inheritance for my dad. But on the other hand, if I don't do it, then, it doesn't look good in front of my other siblings who don't understand why I'm not giving it up. So in order to avoid these sensitive situations, it's so much better just to prepare a will, have it black on white, and then it's not a question of, do I want to give it up or not give it up? Because it's just written what the person wanted and how it's divided, and that's it.
So you sort of are you control how your money is distributed, not the courts.
Absolutely.
And not anything else.
Correct.
Okay.
Correct. Exactly.
And is there an overlap sometimes? Like if you have an American will and an Israeli will, does one of them sort of supersede the other one, or they work in tandem sort of, through the probate process?
Well, it depends. In general, the latest will is the one that applies. So if you didn't divide it as such that the Israeli will is only for Israeli assets and the American will is only for American assets, let's say, and you prepared an American will that includes all your assets worldwide, then the American will, and that's the last one that you prepared, then that will supersede the other, the Israeli will, no question about it. And then it becomes more complicated, because then if you may need a, more paperwork will be involved, and then instead of it going through a regular process, it goes through the court, and that takes more time, and it may take, and it may, you know, it may, you may need to have more expenses regarding the probate. It's not a simple probate suddenly. It's just a big mess, and chaval. Like, it's just much better to divide it and make sure that it's done properly.
Okay. The last thing I'd like to touch on, and this has become a very, very, I would say, hot topic because it's new, and that's the concept of the enduring power of attorney. Okay, people who live abroad who might be watching this will be shocked at what was sort of Israeli law up until 2 years ago or so, until this was introduced in Israel. Can you sort of give us a little background and then talk about how the new enduring power of attorney can help solve people's, provide a solution for people with like elderly parents and what have you?
Sure. So the durable power of attorney or enduring power of attorney is something new, as you said, and it's only from 2017. Meaning up until 2017, if somebody had lost his mental capacity to basically act on his own, then the family members would have to go to court and request to be appointed as guardian. Now, the whole process is very bureaucratic and it's very long. Even if it's a shutdown case of, I had a case of a 95-year-old woman who has dementia, and it's very obvious that she needs guardian, it was still a long enduring case because there was Corona and it was a big mess. But in general, it takes at least 60 days. They need to get a report from the social worker who lives in the city of the person who needs the guardianship. And until she comes, then she has to prepare a whole report, and then it goes to court, and the court has to look at it, and the court may ask some questions, and it's not clear cut. And then even afterwards, even if when the person gets guardian, then he has a yearly report that it needs to give to the Apotropos Haklali, stating all the assets that the person has, all his liabilities, what monies were taken out, why they were taken out, for what purpose they were taken out. And the banks are very much also on top of it in the event that somebody needs substantial amounts of money, even if it's completely justified, but it's not, but it's abnormal, then they'll shut it down. They'll request, go to court, get the court's permission, and then come back to us and we'll take out the money. So, it was not a very happy situation. What happened in the middle of 2017 was the enduring power of attorney, the durable power of attorney, was introduced by law, which basically gives the person a way of appointing power of attorneys. It could be one person, could be a few people, and they will act on his behalf according to instructions that he is already leaving in the document itself, which explains what he wants, how he wants his bank accounts to be handled. Does he want to be moved from his house to a diur mugan or to a nursing home or to wherever? Does he want to go to shul or does he not want to go to shul? Like, everybody can really put in, it's tailor-made to the person's needs, which means every form is different and it's much easier. The idea behind it is that you don't need to go to court. You're not appointed by the court. You have to file it with the Administrator General, the Apotropos Haklali, but you decide according to instructions that you've put in when it comes into effect. The Apotropos Haklali will check that the conditions have been met, and then we'll just give you the okay to start working according to the document, start implementing the document. And most cases, there are going to be some few cases that you will need to go to court, but on a daily basis, you will not need to go to court, and the banks should be, will look at the instructions and have to apply them without making you go to court every 5 minutes for something.
And correct me if I'm wrong, but not every lawyer is able to do this, right? You have to have special certification or something like that?
Yeah, you have to have been through you have to be specially certified by the Administrator General and the Justice, what's it called? The Administrator General and the Bar Association. And not every lawyer is capable of preparing these documents.
Mirit, this was amazing, I must say. I think we should circle back, and we touched on a bunch of things. Maybe we should just next time we should drill down on one or two topics and get more into depth. Once again, how can people get in touch with you?
So again, they can definitely call me or text me on my cell phone. It's 0522 407-999, or they can email me at mirit@lawmirit.com. And they can find me on Facebook if they want, but it's in Hebrew, so I don't know if they'll want to do that. And I also have a website, which is miritlaw.com. So, all options are open.
Thanks so much for joining the show.
Thank you very much for having me.
My pleasure. It's the Aaron Katsman Show. I'm your host, Aaron Katsman, where we speak to you about your life, your money, and your investments. If you got any questions or comments, feel free to email me at Aaron, AARON, at lighthousecapital.co.il. You can find me on the web at www.aaronkatsman.com. Be sure to follow me on Twitter and subscribe to our brand new YouTube channel where you get all of our interviews and all the podcasts and all the content that's coming out directly into your inbox. We'll speak to you all very soon.